Mr. Lloyd, go ahead, please.
Well, thank you, Mr. Chair, and thank you to the witnesses for coming. I will have some technical questions for you, like I did yesterday. But yeah, following up on my colleague, Ms. Dancho's initial statement, I really feel like a red line has been crossed in this country with this amendment. In this country, we don't have a Second Amendment, and I think that is appropriate. But what we do have is a social contract that has existed for decades, for generations in this country. And that is a social contract between the Government of Canada and society, and part of that society including law-abiding firearms owners. And for generations, Canadians have accepted that regulation is an important part of cultivating a responsible firearms culture in this country, a very important firearms safety culture. And over the generations, in response to exceptional instances, horrible tragedies in many cases, governments have seen fit, governments of all political persuasions have seen fit to put forward amendments and legislation to close gaps, to try to prevent tragedies from happening. But whenever those laws were passed, there was always an understanding that there was no intention to target law-abiding firearms owners, hunters, farmers, sport shooters, gun collectors, and there was always a great deal of deference put into the legislative drafting, into having witnesses come, into creating legislation that ensured that that social contract with firearms owners, with Indigenous people, with hunters, was preserved and protected. And I think, one great example of that, and this is going to be a technical question I'll ask, so I'll just kind of put it on your radar, is Section 117.15 of the Criminal Code. And Section 117.15 of the Criminal Code gives the Governor and Council the ability to regulate firearms. But there is a subsection of that, and this was passed in 1995, so this isn't a recent law. This is a law that's nearly 30 years old. In making regulations, so quote, in making regulations, the Governor and Council may not prescribe anything to be a prohibited firearm, a restricted firearm, a prohibited weapon, a restricted weapon, a prohibited device, or prohibited ammunition, if, in the opinion of the Governor and Council, the thing to be prescribed is reasonable for use in Canada for hunting or sporting purposes. So this is the law of the land in this country. It hasn't been changed since 1995, that when the Governor and Council is in the process of changing the classification of a firearm to be a restricted or a prohibited firearm, they must consider whether that firearm could be reasonably used for a hunting or sporting purpose. And I am concerned, and I will ask this as a direct question to the witnesses, is how does this amendment, G4 today, how does it interact with that provision of the Criminal Code? Because I think that's a very important question that we have to answer today. Because, as I said, a red line has been crossed. As much as, I appreciate the opening statement from my Liberal colleague that said that it was not their intention to target hunters in any way, there are a number of shotguns and rifles that have been explicitly named in Amendment G46 that I think any reasonable person would see to be a hunting or sporting firearm. And I think that's quite apparent. And so, for this government to put forward this amendment without any thought to the law of the land really draws a lot of concern for me. And these hunting and sporting rifles, the Benelli M3 was one of them. It's a wooden stock. It doesn't have a detachable magazine, which is interesting because Sub-Amendment G of this amendment, which we talked about Tuesday as the evergreen definition, cites that any semi-automatic rifle or shotgun with a detachable magazine that has the capacity to carry more than 5 rounds. Now, in Canada, it's been long accepted, this is part of the social contract that I talked about, that we do not want to have high-capacity magazines in Canada. And so there has always been a limit on centerfire ammunition that you cannot have a magazine that exceeds 5 rounds. Well, in Canada, we don't really have a huge firearms industry. Most hunting and sporting rifles and shotguns are manufactured in other countries, and other countries don't have this 5-round magazine rule. So any of these firearms, that are being banned, even though in Canada you are not allowed to have a magazine that exceeds 5 rounds, they were all originally designed, for the most part, as far as I know, to potentially carry 6 or 7 or even more rounds. And in Canada, we currently have a ban. It's a criminal offense to have a prohibited magazine. It's a prohibited magazine if it carries more than 5 rounds. And I think that has been a largely effective policy. It has been a policy that has been accepted in this country for many, many years. And so we can use these rifles that could potentially carry more rounds, but no law-abiding person, they would immediately cease to be law-abiding. No hunter would want to use any magazine that had a capacity of higher than 5 rounds. But now the government is saying they're going to approach this from the other end and say, we're not just going to ban magazines that can carry more than 5 rounds. We're going to carry any gun that could carry a magazine that has more than 5 rounds. And in the process of adding that amendment, they are capturing an immense amount of firearms, many of which are used for hunting and sporting purposes. And so this is what I say, a red line has been crossed. Are they banning all hunting and sporting shotguns and rifles? Certainly they're not. But that's exactly how this starts. The government, this Liberal government, will take incremental steps forward, and I would submit that this is not an incremental step. This is a massive step. It's a step that was not talked about in the last federal election or in the last number of federal elections in specific terms. The government has used very ambiguous terms, such as military-style assault weapon, and you know what, I actually agree somewhat with my Bloc colleague who said, we all want a definition. We want a strong definition. But at no time has there been a consultation with the public. Was there an election platform that stated that the definition of what an assault weapon is or a military-style assault weapon would be semi-automatic centerfire shotguns and rifles? And that was never anything that was contemplated. That was not something that we talked about in this committee. It was not something in the original Bill C-21. It's not something that we knew about, so we didn't know to ask witnesses about it. We didn't bring specific witnesses about it. And so in a way, although this bill has, a number of steps in the democratic process to go before it potentially passes into law, the addition of this amendment at this stage does, impugn our democracy, because it has removed our ability at the second reading, which took place, the second reading debate, the second reading vote, and through the committee stage in the House of Commons. It has precluded our ability to bring in witnesses, to bring in experts, to talk about this issue and debate this issue. It's just been table dropped as an amendment after we had completed our vigorous study on this, a study that I would submit did not go very well for the government. I think this C-21 legislation was very poorly drafted. It was very, it was not well thought out. A number of the well-intentioned things that the government put in it were later found to have been extremely flawed. Witnesses from across the political spectrum noted that these things were flawed. I won't get into those specifics, but it became increasingly clear as we got to the end of the process that this bill would have to be amended significantly, and for the government to recognize that these significant amendments were likely coming, they chose to table drop these massive new amendments that, in the words of one person, one lawyer, said is the most significant revision to the Firearms Act since the Firearms Act was passed in 1995. The most significant revisions to the Firearms Act in the history of the Firearms Act. And it's not even being debated as its own standalone motion. It's being debated as an amendment at the clause-by-clause stage of committee. Like, this is not how our democracy is supposed to work. Yes, if this bill makes it to the Senate, there will be an opportunity for senators to look into this. But, the Liberal government, because of this Trojan horse last-minute maneuver has precluded my right as a parliamentarian, my privilege as a member of Parliament, a member of the House of Commons, to study this bill and to debate it on its merits. I'm stuck here at the clause-by-clause stage when the train is already leaving the station, and trying to get answers about what this is going to do. And so I think that raises some very serious implications for the legitimacy and the credibility of this legislation, the credibility of this amendment. I understand, some colleagues will say that they want to, some in other parties, they want to vote for this, but I think surely they could recognize that it is a very bad precedent to set to allow any party or any government to add an amendment that was not conceived of in the original legislation, that was not discussed at all in the witness testimony, that was not brought forward at this late stage in the process. So moving on from that, getting back to the social contract, Canada is not the United States of America, and I think that is a great thing. My family left this country, left the United States, the 13 colonies, in 1783. We fled from upstate New York together with our brothers and sisters in the Six Nations, the Mohawk Nations. We left the Mohawk Valley of upstate New York to move to the Belleville region of Ontario. We were United Empire Loyalists, and we came to this country because we rejected the political ideology of the American Revolution. We're friends with the Americans. They're our allies. We share many common values, but Canada was founded, one of the founding peoples of this nation, the Loyalists, who came from the 13 colonies as refugees to this country with the Indigenous peoples in upstate New York and other places, and with the members of the Francophone, the Quebec Nation, who also, there was entreaties from the United States to ask the Quebec Nation to join in the revolution, and they rejected the revolution. So this country was founded as a rejection of the revolution. And I think that is a great thing, because I am a Canadian patriot. I believe in this country. I believe in the reasons that this country was founded. And I believe that we are a distinct society. We are distinct from the United States. And that's why it actually offended me. I do respect my colleague, Mr. Chang, and his service in the police service, but it did offend me as a Canadian when he moved this amendment to cite a California law that we need to be implementing California American-style laws in this country. I don't have these statistics in front of me, but I can bet that the murder rate in the state of California by firearms is far greater than the murder rate in this country, and that's something I'm very proud of in this country, is that we're a safer country, by no means a perfect country, but we are a country that has better firearms laws than any state in the United States. And for this Liberal member to come forward and cite an American law in the American context as a reason to pass a new law into Canada, I think that's wrong, because we are Canadians. We have our own way. We are distinct. We do not need American-style laws in this country. We do not need American divisive political rhetoric in this country. And you know what? I think, frankly, it does. I'm a big fan of George Grant and his work, Lament for a Nation, and we have seen, and in his book, one of the theses is that the Liberal Party of Canada has always found political power by importing American cultural debates into this country. And they are breaking the social contract. This has eroded the social contract in this country. And I'm going to say why this is super dangerous for our country, why the social contract has been broken, the result of this social contract being broken, why it's so dangerous. But first up, why is this Liberal government breaking the social contract with hunters and law-abiding gun owners? Is it because of public safety? Well, no, because we've seen from the witnesses, from police, from people that are working in our inner cities, that these firearms are, and we're talking about handguns, we're talking about fully automatic firearms, which are heavily restricted or illegal in this country, are being smuggled in from the United States, a country with far different gun laws than we have, and they are being used to commit crimes on our streets. These are not law-abiding hunters and sport shooters. They're not using many of the firearms that the government's listed in G46, like a Benelli M3 shotgun. It wouldn't be used by people who are committing crimes on our streets. And so for the government to list that is a clear violation of our social contract. And why they are doing that is because they have recognized that this is a divisive political issue that they can use to divide Canadians between rural Canadians and urban Canadians, between Canadians who own firearms and Canadians who don't know much about firearms, don't own firearms, and are afraid of firearms. They've recognized this as a way to divide Canadians for their own political success. And I think that's wrong, because we are eroding something that is very fundamental about our country. Something that is very fundamental to our identity as Canadians is that we have this social contract where firearms owners do not have explicit rights written into the Constitution of this country, but that this country respects the rights of law-abiding firearms owners who follow the law, who go through the process, who get vetted by the Canadian Firearms Program, by the RCMP, who can have their guns taken at any time by the police, even without a warrant. If anyone calls into a police station with a claim that somebody is a threat to themselves or to others, the police have the power to act. That's something that doesn't exist in the United States, but it exists in Canada, and I think that's a positive thing. Because as somebody who comes from a family of gun owners, we never had to be worried that our government was going to pass legislation that discriminated against us, because we knew that as long as we followed all these rules, reasonable rules that have been accepted for generations and decades in this country, that we would be respected by our government. And it is only under this Liberal government that that social contract has been violated, and not for public safety reasons, which I think, we could look into, but for purely political division reasons, purely for their own political gain. And I think that's a shame on the Liberal Party of Canada. And I know they have lots of members who live in rural areas, who probably own firearms themselves, who are probably concerned about this legislation. I don't know how much consultation they probably did within their own caucus on this. I won't speculate on that. I don't know. But I just think it's just so shocking to me that they would cross this red line, and that they would delve into an area about shotguns and rifles. And so, moving on, I see that the government, and actually it was one of my questions, when I first saw this list of guns, the 310 pages or so, and G46 come out, I was just really curious, why is the government putting this list as an amendment to C-21? And in looking at the list of guns, it quickly became apparent that a lot of these guns had just been copy and pasted from the May 2020 order in council. But we have since discovered that there is somewhat, based on testimony yesterday, between 300 to 400 additional firearms that have been added onto the May 2020 list. And so I thought, well, why would this Liberal government need to pass this as an amendment? If these firearms are a threat to public safety, they could have the authority, and I guess I'll see it in my quick question. Does the government have the authority to add these firearms to the banned list using an OIC immediately? That's my question.
I'll start from first principles, which is that the government has the ability to prohibit firearms through two means. The first means is through the power of prescription, which is set out in Section 117.15, and also set out in the definition of prohibited firearms. And as you mentioned, and then the second way is through legislation, which is what is being proposed here today. You mentioned earlier, and I will proactively respond to your question about the limitation on the Governor and Council when prescribing a firearm by order in Council, that the Governor and Council must be of the view that the firearm is not reasonable for hunting and sporting purposes. Going back to the May 1st OIC, the regulatory impact analysis statement stated throughout it a number of times that the Governor and Council was of the view that these firearms posed too great of a public safety risk in order to be to not be prohibited, to remain non-restricted or restricted. So going back to your original question, yes, the government could prohibit the additional 400, I don't have the exact number, but the additional firearms that are listed by regulation. But what is being proposed is those firearms be prohibited here today through motions that would amend legislation.
But it would be more immediate for them to do it through an OIC. Would you agree that it would be a faster process to do it through an OIC than it would be through legislation?
It would be a faster process, but what's being proposed is that the process be part of the legislative process before Parliament.
I appreciate that. So that question tells me that there is no urgent public safety need to ban these firearms, because these additional 400, because the government has not banned them through an OIC. And so they're willing to wait weeks and months, depending on how long this legislation passes, to let these firearms be added to the legislation. So that indicates to me that it's not because of any urgent public safety measure. What are the other, if you can say, what are the other, I know, and Ms. DeMoff stated that the reason they wanted to add this to the legislation was to prevent a future government, and I think a conservative government, they said, from repealing it using an order in council. It is their intention to add this to legislation so that a future government would have to explicitly pass legislation to repeal it. That is your understanding, is that correct?
That's correct. Any amendment to the definition of prohibited firearm that is set out in the criminal code would have to be amended in the future through the parliamentary process.
Now, are there any court cases ongoing right now that this would have an impact on?
To any ongoing litigation.
Okay. It's just interesting to me that you mentioned a regulatory impact statement that the government used to say that these firearms were too dangerous, so they were not considered reasonable for a hunting and sporting purpose. Is that a public regulatory statement?
Yes, it is. It's attached to the regulations that were published on May 1st, 2020.
And is there information in that, and maybe you could send that to the committee, I'd appreciate that if you could. Sure. But is there anything in that regulatory impact statement that says, like, the government, did they just come out and say it is our opinion that these are too dangerous? But was there any consultation done? Was there any evidence that they provided to back up their assertion that these firearms were too dangerous?
So as my colleague mentioned yesterday, or 2 days ago? Yesterday, that 2 days ago, that the government did undertake consultations in 2018. They're broadly based consultations, and there's a report that's published that sets
I'm aware of that.
Okay.
I read it yesterday. Thank you after you noted that to me.
Okay, so
I would note in that legislation that there was never any direct consultations on semi-automatic rifles and shotguns, though.
okay.
Are you aware? Am I wrong? Was there ever, I saw there was a survey where they asked a number of questions. Was there any questions about whether or not the government should ban semi-automatic rifles and shotguns?
So that is actually a question that I will defer to my colleague at Public Safety.
So thank you for the question. So with regards to what was consulted on in 2018 and what made the basis of that regulatory impact analysis statement, I would refer you to that regulatory impact analysis statement.
I'm having trouble hearing you. I did have my,
I'm sorry. Can you hear me now?
maybe my thing isn't working, but I sort of, you were faint, but you were referring to me to the regulatory impact statement. But are you aware of the government's consultation that took place, I believe, in 2019? You're aware of that consultation?
I am
Are you aware of the contents of that consultation?
Broadly.
Broadly. Now, are you aware, can you confirm or deny whether or not the government asked those that they consulted whether they supported a ban on semi-automatic shotguns and rifles in that consultation?
So I cannot. I am here to provide information and information with regards to the motions that have been put forward in terms of the effect of those.
Okay. Thank you. Are you aware that one of the survey questions, and I think it was a kind of a very leading question, because we don't have a definition of what an assault weapon is, but that one of the survey questions were, does more action need to be taken to ban assault weapons in this country? And are you aware that 77% of respondents to the government's consultation said that they thought that we had enough regulations or did not need more regulations for so-called assault weapons in this country? Are you aware of that statistic in that consultation?
Thank you for your question. I think that's a question that I think I would invite you to pose to the minister.
Yeah, I know, it's, I'm having a problem as well.
Sorry, can you hear me now? Okay, thank you. Thank you for your question. That is a question I would invite you to pose to the minister.
Yes, it seems like we have about as much luck getting answers from the minister as we seem to be having today, but I thank you for your efforts to do that. A lot of concerns I have here is like maybe getting down into how this, the consequences of this legislation, should this amendment pass. Will anyone who owns these firearms, how will the process work? Because will they be immediately committing a criminal act for possession of these firearms?
No, the proposed amendments to the definition of prohibited firearm would not come into force on royal assent. They would come into force by order in council, which means they would come into force at a later date.
And is there a prescribed number of days that order in council has to come into effect?
There's not.
So it's sort of like a sword of Damocles for firearms owners once this passes, that, basically the government doesn't need to regulate these things right away, but the government could be holding it over their heads at any time, and at any time they could decide, it could be 30 days after this passes, it could be 2 years after this passes, but it's something that, they can hold over their heads for as long as possible. Perhaps something they could hold over as something to bring up during an election, perhaps, but I would never want to accuse them of that. But it would also demonstrate that, perhaps this is less about public safety and more about politics. If this order in council, when the order in council is triggered, what would be the effect of that triggering? Or is that something that has still to be determined by the regulations?
Future steps with respect to how the newly prohibited firearms would be treated has not been determined at this point. I would remind you, though, when the May 1st OIC came into effect, there was an amnesty order, and that gave lawful owners an opportunity to either dispose of their firearms or otherwise come into compliance with the new law. So they have a period of time during which they are not subject to criminal liability for unlawful possession, and then a decision would be made by the government as to how to move forward with the treatment of any newly prohibited firearms that would be included in this amended definition.
So what you're saying, without repeating everything you're saying, is that the precedent that this government has set that is being implemented is that there is an amnesty period following the May 2020, but you can't say for sure whether that is going to be what follows this one.
So what I was saying is that for the May 1st, 2020 OIC, an amnesty order was included the moment that the firearms became prohibited. So firearms owners were not exposed to criminal liability. There was an amnesty order in place. I cannot comment as to what would happen if there is an order in council that brings these provisions into force, but I can refer you back to what the government has done historically.
Thank you. I do appreciate that.
Okay.
I'm not trying to put words in your mouth. I'm just trying to understand what you're saying. There has been some concern that because the May 2020 OIC was passed via an OIC, that it is subject to the laws of Parliament, like that it is, that it is below a law of Parliament, whereas an act of Parliament, which is what this proposed amendment would be doing, puts it sort of on equal step with other parliamentary laws. Now, if the government sets the precedent that they're going to ban these firearms in legislation, does that preclude their need to provide a statement, as I mentioned in 117, that they believe that this is not reasonable for use in hunting? Do they no longer need to provide that justification if they pass this through legislation?
The justification that you're referring to applies to firearms that are prohibited by regulation. So that's a limitation on the Governor and Council's ability to exercise their discretion to determine whether or not a specific firearm should be prohibited. The democratic process is what would be used to debate whether or not these firearms should be prohibited through legislation.
Yes, and so I guess I just want to confirm what you're saying is that the governor and council rule does not bind the government if they pass this legislation from providing a justification about why these hunting rifles should be banned.
So
That's a protection that exists only for the governor and council regulations, but not for legislation through parliament. Is that correct?
the ability of the governor and council to prescribe firearms is a delegated power that comes from Parliament.
Of course.
And when this provision was enacted, Parliament imposed a limitation on the governor and council as to what firearms could be prohibited.
And now the government is saying we don't want that limitation anymore because, as we have said, they want the power to ban hunting rifles. And so that's why they're circumventing this very reasonable limitation, I think, that existed in the 1995 firearms law. And, you know, I think that just proves further evidence points that this is really about giving the government the power to move forward and limit all sorts of new hunting firearms. They're just going to do this through a legislative process instead of through a governor and council, where at least they would be held accountable and have to justify why these hunting rifles could not be allowed. So another follow-up is that the Bill of Rights, the 1960 Bill of Rights, is still a law of this land. I mean, we have a Charter of Rights and Freedoms, which is very important. But the Bill of Rights says very explicitly that Canadians have the right to life, liberty, security of the person, and also the right to enjoyment of property that cannot be deprived except with due process of law. And so if the government, under the governor and council, are they bound by the Bill of Rights when they come up with policies to confiscate firearms? Are they bound by the due process of law in the Canadian Bill of Rights when depriving people of the enjoyment of their property?
Sorry, my earphone's not working, but what I can say is that the Supreme Court ruled in, I think it was 1991 or 1992, in the firearms the firearms reference case, that there is no right in Canada to possess firearms.
I don't disagree with you. But in terms of property, if you are given the right to own a firearm as property, firearms are property as well, the government can't just seize that property except through due process of law. Would you say that is correct?
So I think one of the questions is with respect to the federal criminal power, and the reference firearms decision by the Supreme Court of Canada determined that firearms and the regulation of firearms falls within the criminal law power versus the provincial power over property. And it also indicated that there was no right to firearms in Canada.
But this is the Bill of Rights. This is a federal law, not a provincial law. Are you aware of the Bill of Rights? Is it still in force in Canada? Like, it still has power in this country, the Bill of Rights?
Yes. Yes, it does.
And so what I'm getting at here is that it seems like the government, you know, is trying to, through the buyback program and the May 2020 OIC, trying to respect the Bill of Rights and say, we're going to confiscate your property, which is a violation of the Bill of Rights, but we're going to make it up to you because we're going to compensate you for that property. It happens all the time in this country, eminent domain laws, you know, when people have their property seized to build a highway. The government has to compensate you for that. That's the due process of law. But if the government passes this amendment that we're talking about today, G4, and it's not, is it notwithstanding the Bill of Rights? Because is that something that the government's saying, that this will be notwithstanding the Bill of Rights protections for property rights?
So the criminal law falls under the criminal law power that is under the federal jurisdiction. And that's what I can point to when we speak about criminal law and this legislation that is being amended through the bill and the motions. It is under the federal criminal law power.
Yes, I understand that. I guess what I'm trying to say is that because this will be an act of Parliament and not a regulation, as we've already cleared up, this bill will be on an equal playing field with the Bill of Rights, and therefore will not necessarily be subject to the Bill of Rights protections on property right. And so what I'm submitting, that the reason for another additional reason why the government is submitting this through legislation is not only, as they said, to prevent any future government from repealing these OICs, they would have to repeal it through legislation, but they're doing it to relieve the government of any responsibility to compensate people for their firearms. And that's something, that's something that I think is very worrisome. Because, as I'm going to get here on my next line of questions, it's very clear from a Conference Board of Canada report that the hunting and trapping and sport shooting sectors were responsible for upward of $13.2 billion of GDP in this country in 2018. And that represents about 0.6% of Canada's GDP at the time. That is an extremely significant amount of GDP. Now, I know a lot of these hunters and sport shooters, it's a tourism industry. A lot of these people come in from the United States. Can you tell us how this amendment would impact Americans who want to bring, let's say if the Americans were bringing a firearm that was listed under this amendment, would they be able to bring that firearm up? Do they get an exemption? Because obviously they don't need to have a Canadian firearms license to come up here as a tourist to shoot. So would they be required to not bring any firearms that would be covered under this amendment when they come here to sport shoot?
Thank you for the question. In terms of if the motion and the bill passes and it receives royal assent, the same rules that apply today in terms of if you're bringing in a non-restricted, in terms of the processes and procedures, the same thing for restricted, and I believe for prohibited firearms, you cannot bring them into the country. You would have to use another, an American, for example, that would be coming in to hunt, would need to bring in a firearm that was, that they could legally bring into Canada.
So so what you're saying is that if this legislation and this amendment passes, that a number of these new firearms, if like a tourist was coming to this country to spend tens of thousands of dollars to hunt big game, if they only had these prohibited firearms, they would not be allowed to bring those prohibited firearms into this country. They would have to find a non-restricted firearm to bring into this country. Is that what you're saying?
They would have to bring one in that they can bring in, or they would have to make arrangements to use another firearm.
To use a non-restricted firearm, a non-prohibited firearm, is that correct?
They would have to use whatever they can that is legally allowed here in Canada.
Interesting. Yeah, very concerning because, if the definition that we're bringing here is any semi-automatic rifle or shotgun that is capable of carrying a magazine over 5 rounds, I know a lot of tourists that come to this country to spend tens of thousands of dollars on one trip alone, they wouldn't be able to bring their firearms. And so they would just choose not to come to this country in the first place. Has there been any economic analysis done by the government on the impact on tourism, like the sports and hunting tourism, that this amendment would have an impact on?
Thank you. I don't believe that there has been.
Okay, thank you. So the government hasn't even done an economic analysis on the impact of this sweeping new legislation. And that's just talking about tourists. I mean, let's talk about, the Canadians, like over 1 million, 1.3 million Canadian hunters in this country who contribute to our GDP and who, are tax-paying citizens who abide by the law and generate this generates economic activity in our country. And we're talking about upwards of $13.2 billion. And I believe that this legislation could take a significant chunk of that out of our country. And the government hasn't even provided an economic analysis. And it just speaks to the fact that this has come, very late in the committee process. We could have had witnesses. We could have asked the minister questions. We could have had people bring economic analyses so that we could have studied this. But unfortunately, we haven't. With that, Mr. Chair, I think I'm going to cede my time to my colleague, Mr. Motz. I know, Mr. Chair, you found it very riveting, what I've had to say, and very educational as well. And so I thank you for giving me this time to speak to the committee. Thank you.